The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
Good morning. The COVID-19 pandemic required many adjustments of the justice system. Social distancing and group size restrictions, as well as substantial hardships on counsel traveling to Austin, do not allow us to hold arguments in the courtroom. Rather than submit cases without argument, we have decided to proceed through remote connections. Court staff and staff from the Office of Court Administration have made every effort to prepare us and counsel, but of course there may be glitches that will require patience. Otherwise, we will proceed as we would in person. The arguments are being live streamed this morning and a recording will be available later today. We're ready to hear argument in cause number AP-77-071, John Ray Falk Jr. versus the state of Texas. You may proceed.
Good morning, Your Honors, and may it please the court. My name is Thea Pozell, and I represent the appellant John Falk in this case. This is an appeal from a verdict of death out of Angelina County on change of venue from Walker County. The hallmark of American adjudication is the adversarial system, born of a conviction that a fiercely contested process is more likely to produce a reliable outcome. In criminal cases in particular, we rely on adversarial wrangling to enforce the procedural protections enshrined in the Constitution, to promote verdicts and sentences in which we can all have confidence. In most cases, the state's adversary is defense counsel, who zealously safeguards the defendant's interests. In a few cases, the state's adversary is the defendant himself, having chosen to act as his own lawyer. And often, such pro se litigants are just as vigorous opponents as bona fide defense attorneys. But in this case, where the death penalty hung in the balance, the state effectively had no adversary at all. Here, Mr. Falk discharged counsel and conducted no meaningful voir dire, allowing the state to handpick the jury. Then, Mr. Falk pled guilty to the indictment. In the punishment hearing that followed, he declined to cross-examine the witnesses against him, made no objections, offered no evidence of his own, and made no argument to the jury. The trial court's comments on the record.
Counsel,
Yes,
isn't that his ability to do that though? I mean, if the defendant wants to represent himself, he has a right to defend himself. And if he wants to do all the things that he did, doesn't he just get to do that?
Well, he does have a Sixth Amendment right to represent himself, but under the circumstances of this case, it begs a separate set of questions. So under these circumstances, when a defendant willfully chooses to leave the prosecution utterly unchecked, what constitutional safeguards must nevertheless be enforced in the name of fundamental fairness and the integrity of the judicial system?
Counsel, was there standby counsel appointed?
There was standby counsel, but the order restricting their participation was fairly strict. And as we mentioned in our brief, we have a separate challenge to the restrictions placed on standby counsel. Some of the questions I think presented by this case are, if a defendant is determined to plead guilty without counsel, can the trial judge disregard otherwise applicable due process requirements? And must the trial judge sit idly by if he perceives that the state is taking advantage of the defendant's lack of participation to deploy its peremptory strikes in a discriminatory manner?
Is there any evidence that the trial court did have such a perception in this case?
Well, Your Honor, immediately following the jury selection in which the state's pattern of strikes, we argue, established a prima facie case of discriminatory intent, the trial court interrupted standby counsel's objection and said he had something to say of his own. And he then made a speech about how both the Texas statutes and the Constitution contemplate a truly adversarial contested process. And he observed that we weren't going to have that in this case. And he described himself as in a quandary and viewed himself as unable to intervene, but invited the appellate courts to correct him if that was not the case. So I think based on the pattern of strikes that we observed here, where the state exercised its first 9 peremptory strikes in a row against women jurors and entirely eliminated Black jurors from the veneer, and utilized the shuffle, which this court has recognized as a relevant circumstance in considering whether a prima facie case was established. I think the trial court did observe what was happening, and everyone in this courtroom knew that the adversarial process had entirely broken down.
Counsel,
I think that
counsel, to sort of get in on the idea that you're saying that the adversarial process is broken down, and your argument is that if the adversarial process breaks down, the judge is supposed to step in and question, has a duty to sort of question what's going on. But if we're going to say that, why wouldn't we Batson has like several steps. Why would we stop there? Why wouldn't we then say a trial judge not only supposed to ask for a race neutral reason by the part of the prosecution, then are they supposed to rebut that themselves? And if that's, how is a judge supposed to do that? Isn't the judge stopping being a judge at that point and starting to be an advocate?
I understand the question, Your Honor. And I think under these circumstances, the trial judge could have asked for race and gender neutral reasons to be entered into the record. And then had he had suspicions about the legitimacy of those reasons, he could have performed the step 3 inquiry. But even if he had not, then this court could review those reasons. This court has reviewed cases in which a prima facie case was not found by the trial judge, yet looked at the record, determined that a case did exist, and remanded for a full and fair Batson inquiry. So certainly the trial judge would not have a duty to intervene in every case, but here the pattern was clear. I think because Mr. Falk exercised no peremptory challenges and the state used 13, the entire petit jury was chosen from the first 25 qualified jurors. And the gender breakdown of that first 25 was about as even as an odd number can be. There were 13 women and 12 men, and yet the state struck 10 of those women and accepted 9 of those men. So even on those facts, leaving aside the fact that African-American jurors were entirely eliminated from the jury panel, and the state ended up picking an all-white jury of 9 men and 3 women, on those facts, I think the trial court did have the duty to intervene, and it appears that had he known he had the authority, he may have done so.
Isn't there a difference though between putting on the trial court a duty to start doing this versus just recognizing, say, the ability to ask this question if something looks really, really bad? I mean, it's one thing to say that the trial court has the authority to question these things, and a lot of your case law seems to say that. But I'm not really seeing how this affirmative duty flows from Batson.
Well, I think part of the reason why many of our cases, in fact, all of the cases we've cited recognize an authority to do so because the procedural posture of those cases are defendants challenging the trial court's authority to have intervened and rejected defense counsel's race neutral reasons. So that indicates that there are fundamental principles of equal protection that must be observed in jury selection, and even the defendant must be held to them. I think, we cite a Fifth Circuit case of Mata versus Johnson,
excuse me, but you're saying the defendant has to be held to them? Are you requiring the defendant to effectively represent himself? And if he doesn't, then you're raising the ineffective assistance claim?
No, Your Honor, I apologize. I meant in the fact that neither defense counsel nor the state may exercise peremptory challenges in a racial or gender-based manner. So it's a fundamental principle that underlies jury selection as a process, and defense counsel certainly can't violate it in the same way the state cannot.
So you're okay with the idea, though, that the trial court could start questioning the defense on their peremptory challenges as well? I mean, under your proposed rule, that's what's going to happen. 2 is that the trial judge is going to be able to start questioning the defense when they try to exercise peremptory challenges. Are you sure that we're ready to do that?
Well, respectfully, Your Honor, I think in most cases, the state is in an adversarial posture to the defense. So if the state, and there are certainly cases in which the state does ask the defense counsel to provide step 2 or race neutral, gender neutral reasons. So in that case, the adversarial system has not broken down like it did here. I think this is a unique case in many reasons, and one of those circumstances is that there was just entirely no check on the prosecution's use of strikes.
So your rule only goes one way?
Not necessarily. I mean, were there no counsel representing the state in a proceeding, perhaps the judge would then have a duty to intervene, but just as this is a very unique.
If there's no counsel for the state in the proceeding, then there's no proceeding.
Sure. I mean, in effect, it may exist in these very unique circumstances where there's just no contested process. But I do believe in the Fifth Circuit case, which I acknowledge is not binding on this court, but Mata versus Johnson, the Fifth Circuit recognized that equal protection in jury selection is a fundamental principle that is not waivable even with partisan consent. So this is certainly not binding on this court, but that is the exact language that this court uses for Marin Category 1 errors, fundamental principles, absolute rights and prohibitions that are not waivable even with partisan consent. So I'd like to briefly, in my time left, turn to the plea issue in this case.
Before you do that, let's just play this out to the logical conclusion. And that is the trial judge makes the wrong decision, in your opinion. Then are you putting him in as a witness when you get to the writ level? Is somebody going to put him on the stand and ask him why he didn't exclude a juror? Because that's effectively what you're doing.
Well, I think what we are asking for in this case is simply a recognition that there was a prima facie case evident from the state's pattern and a remand for a full and fair Batson hearing. So
Yeah, but you're asking for that. But if you don't agree with his ultimate decision when he intervenes, then he becomes a party to the case somewhere down the road. Because at some point, if you expect the judge to do that and you don't agree with his decision, then you have to have a way to question him on that. So you're making him a party to the case. How are you going to get around that?
I actually think that even in Batson challenges where the defendant doesn't agree with the ultimate decision, the judge is not a witness in that case. And we're not asking to disturb the Batson framework in general. I think we're saying that what raises a Batson issue is not necessarily a defense's objection if he's not participating, but rather the clear pattern of racially discriminatory.
Excuse me, but if you remand this for a full Batson hearing and the defendant represents himself again, are we just going to go round and round and round about this if he doesn't object to the peremptory challenges that the state makes or strikes?
I don't believe so, Your Honor. I think if this court looks at the record and observes, as we think is clear, that a prima facie case did exist, then the remand would address the race neutral and gender neutral reasons offered by the prosecution and the trial judge's assessment of those. And there would be no need for the defendant to again object once a prima facie case has been found. So if there are no further questions, I'd like to turn to the plea briefly. I think the Supreme Court has made very clear that a trial court has an affirmative duty to establish on the record at the time of the plea that the plea is constitutionally valid, and it must be a record sufficient for review of that issue. Due process.
Are you saying that the trial court gave no admonishments in this case?
The trial court did give the admonishments, Your Honor, but the statutory admonishments don't measure a defendant's understanding of the law in relation to the facts of his case, which is the second prong of the due process analysis, and that's not present here. And I think in Davison versus State, this court recognized that the Article 26.13 admonishments, violations of that statute are measured by a different test than constitutional due process claims of involuntariness. And that's what we have here. So the question is whether the trial court established on the record that Mr. Falk understood the charge to which he was pleading and how he was guilty of it. And the record here simply does not establish that. And in the absence of a record that establishes the plea is voluntary under due process, this court must presume it was not and reverse. There are two presumptions in our system that often save invalid colloquies such as this one. Where a defendant is represented by counsel, there is often either an explanation by the trial court of the charge to the defendant, and then the trial judge will elicit statements from the defendant that he understands and is guilty, or there is assurance on the record by defense counsel that counsel has done the explanation, explained the elements and the nature of the charge, and that the defendant understands it. But neither of those things are present here because of the circumstances of this case. And the other wrinkle in this case is that Mr. Falk pled guilty to an indictment that described wholly the acts and mental state of another person. Now, this court has held that the law parties need not be pled in the indictment, but this case is unique because there's no theory, and the state has never contested, there's not a spread of evidence to indicate that Mr. Falk was guilty of this crime at all in any way other than a party.
What did the stipulation actually say?
The stipulation mirrored the language of the indictment entirely with the inclusion of the phrase alone or as a party. And I think merely those several words do not establish that Mr. Falk understood, first of all, what that meant. He made no factual admissions as to his own conduct or mental state. There was no proffer by the state of what the evidence would show at trial had he been taken to trial and had the jury determine his guilt. He made no statements that he understood how he was guilty under the law of parties or discussed his own conduct that would bring him within the confines of that law. So the combination of the lack of any specific acts or mental state of his in the indictment and the mirroring language in the plea, and the trial court's colloquy here was simply, do you understand the charge against you? And then Mr. Falk said yes, and he said, I find that you understood the charge. He did not go over the elements of the crime with Mr. Falk. And were the jury to have heard this case, they would have received what this court is familiar with as an application paragraph that would, again, mirror the indictment, insert the phrase alone or as a party, but immediately before that, the jury would be reminded of the law of parties and the various theories of liability in the abstract instruction. So Mr. Falk did not even get that here.
But there had been a previous trial. Am I correct about that? And in that trial, the concept of the law of parties was at least touched upon, correct?
That is correct, Your Honor. But as this court is also familiar, that case mistried over a dispute between the state and the trial judge over the application of the law of parties to Mr. Falk's conduct. And so I think there are two problems with relying on the fact that he was tried before in this case. First, the trial in this case is not a part of this record, and Boykin clearly requires facts in the record in the colloquy itself that establishes the defendant's understanding. And this seems to be a case of first impression before this court, but other courts have held that it was improper of intermediate courts to rely on previous proceedings. We've cited a Georgia case in our authorities, Lejeune versus McLaughlin, in which the Supreme Court there reversed the intermediate court and found the plea to be involuntary under due process.
Counsel, did you intend to reserve some of your time for your rebuttal? Because you're down to about 1.5 minutes.
I did, Your Honor. Thank you. I think, furthermore, if Your Honor is suggesting that extra record evidence could support the assumption that Mr. Falk understood the application of the law to his own acts, the Supreme Court in Henderson rejected that notion. They note that in that case, the court would assume that the defendant would have pled guilty anyway had he been properly advised. And in that case, he was represented by 2 competent counsel. And the Supreme Court noted that such an assumption was insufficient to save a constitutionally invalid plea colloquy such as this one. So furthermore,
excuse me, counsel, doesn't explaining the law of parties to him though make him look like he has less of an avenue other than pleading guilty? I mean, it makes him look more guilty if he's gotten this instruction or he's gotten this information that it's someone else and he still pleads guilty. I don't see how that makes his plea less voluntary to then further explain to him that no, even though this stipulation points to this other guy, you're still guilty under party liability. That seems like that's going to make him. I don't see how that makes his decision to plea less voluntary.
well, Your Honor, it was clear to the trial court and standby counsel and everyone in the courtroom that Mr. Falk was simply rolling over and acquiescing to the prosecution in this case. So,
right.
Touching on the fact that he had standby counsel, are you saying standby counsel wouldn't have talked to him about the charges against him and his role in the crime?
there's nothing in this record to indicate that they did, Your Honor, and the Constitution requires that. And I see that my time is up, so I'll return on rebuttal.
Thank you, counsel.
May it please the court. My name is Gwendolyn Vindell, and I represent the state out of Walker County. Appellant ultimately disagrees that a defendant should have the right to represent himself in a death penalty case. In each of his claims, he tries to chip away at that fundamental right by asking this court to impose 3 new rules. First, he seeks to impose a duty on trial courts to sua sponte raise Batson objections, but he ignores that under this court's clear precedent, he has forfeited his Batson claim by failing to object. Second, he argues that a guilty plea can only be voluntary if a defendant is admonished on the precise way the law of parties applies to his case. But he ignores that, duty or not, on the record in this case, one cannot imagine an appellant more well-versed in law of parties than Mr. Falk. Third, appellant would require greater evidence of criminal liability to support a guilty plea when law of parties is involved. But in this, he ignores that he stipulated to all available theories of liability.
Counsel, did the state voir dire on the law of parties?
Yes, it did, Your Honor, with practically all of the 70 jurors that were questioned individually. Additionally, Falk, appellant had counsel through the first half of voir dire, and his counsel also asked many questions about law of parties. He also sat through 2 days of general voir dire by the trial court. Therefore, notwithstanding questions of whether the first trial that he sat through, which appellant did describe in his brief as clearly establishing that the state was proceeding on a theory that appellant did not actually cause the death of Mrs. Canfield, but was legally responsible under the law of parties for the acts committed by Martin. If we were even to put that aside, the evidence in this trial alone is more than sufficient.
I think
Indeed,
counsel for the defense suggested or seemed to suggest to me that we can't look at the record of that first proceeding. Is that your understanding? And if not, why?
I would disagree with that, Your Honor. Certainly, that record is not part of the appellate record here. However, this court could certainly judicially notice any of prior public proceedings. And importantly, the application of the law of parties to the facts of appellant's case was precisely what led to the mandamus proceedings and the published opinion in this court. Certainly, this court can look to that as evidence, as the Supreme Court and this court have found over and over again. A defendant's prior experience with the criminal process is directly relevant to the voluntariness of any number of waiver of rights. And here, again, it is evident from that first trial that he is more than sufficiently aware of that. It is also evident from this trial, and specifically, we have direct evidence of his knowledge here. He asked 4 different jurors and made reference to the law of parties when he was conducting voir dire on his own. With respect to one of those jurors, he agreed to excuse her with the state because she refused to agree that all the parties in a criminal offense were equally liable. Moreover, with respect to the other 3 jurors, he was asking them about their understanding and their ability to apply the anti-party special issue, which again evidences a very sophisticated understanding of how law of parties applies in his case, because it means that he was aware that this special issue only comes in play when you are convicted as a party. This evidence is conclusive that on this record, even if an understanding as to this precise way the law of parties were to apply in any defendant's case was required, it would blink reality to believe that appellant himself did not possess that understanding.
Let me ask you a question here. I think in punishment, there was evidence that the appellant in this case actually took a gun from one of the other guards and was actually shooting at the victim. Did any of that evidence come up in the first trial?
It did, Your Honor. The evidence was largely the same in both trials. And so there is specific evidence that appellant himself was intending and more than anticipated that he might cause the death of somebody.
And do you think that with that kind of evidence being presented, it would seem pretty obvious that he was pretty familiar with why he might be a party to this offense when he was actually shooting at the victim and missed?
I will wholeheartedly agree with that, Your Honor. I think the evidence is clear.
Okay, thank you.
Turning to the Batson issue. Initially, appellant concedes in his brief that he raised no objection at any point in trial as to Batson. Thus, under the law in this state and in almost every other jurisdiction to consider the issue, the claim is clearly forfeited. He now attempts to end run around that fairly straightforward result by arguing two separate.
Counsel, I was going to ask, Batson is Batson really about the defendant and his right to a particular jury, or is it about the rights of the community to be seated on the jury?
It's both, Your Honor. Batson itself was clearly personal to the defendant, and in that the defendant himself shared an identity with the protected class that was being discriminated against. However, all the Supreme Court jurisprudence after that certainly expanded that to encompass as well the rights of the third-party jurors. Both are at issue here, but while that is sufficient to vest standing in both the defendant and the state at trial, that doesn't mean that those run concurrently forever after. And because the defendant,
if we're concerned about making sure the jurors get on, why wouldn't we create an affirmative duty for the judge to protect those jurors in the community to be their right to be seated on a jury?
I think there are a couple answers to that, Your Honor. First of all, just because there are external interests in the trial and external rights does not mean that we wouldn't require still the parties to assert their own rights on their own behalf. And so in this case, it's very similar to a public trial claim. There, the public has an interest. There, the other parties have an interest in that. And yet we still require the parties to raise those objections on their own at trial or forfeit it on appeal. Indeed, the Supreme Court has noticed that where they fail to do so on direct appeal, then we would look at it on collateral review under the normal ineffective assistance of counsel standards.
I'm familiar with Weaver versus Massachusetts, but isn't the public trial right just a little bit different than making sure you get a jury or get the particular jury? Because public trial rights might affect one part or another part, because you're talking about, as in Weaver, you're talking about there wasn't enough room during the voir dire, right? There may not have been enough room for all the public to fit in during a closing argument. So you can sort of piece together different parts of the trial and go, was this public trial right really violated by the fact that during this one section, there was a really crowded courtroom? But when you're talking about the jury, you put that jury together, that jury is going to carry through the entire proceeding. Is it so? I kind of wonder whether or not these are whether you can really make that sort of analogy.
I would respectfully disagree, Your Honor. I think here, again, with a public trial claim, however, with whatever part of the proceeding we are looking at, it is still structural error when there is an issue there. And although the Supreme Court hasn't specifically held that structural error applies in Batson on direct appeal, it is effectively worked that way. But regardless, this question is still about the defendant's rights on appeal. And as this court noticed in Batiste, or held in Batiste, it is somewhat difficult to see precisely what right of the defendant is involved in a Batson claim when there is Batson error. And as such, I think, yes.
I'm sorry. I thought you were finished answering the question. So if you aren't finished, please continue.
Oh, no, please, Your Honor.
Well, I just was wondering about a hypothetical, and I wondered what your response to it might be. If the state and the defense both were openly and notoriously in court suggest to the judge that the reason that they wanted to strike a particular veneer member was because of their race and no other reason, should the judge intervene in that circumstance to prevent such a discriminatory action?
Yes, Your Honor. In that circumstance, we would not ask a judge to stand idly by and watch blatant discrimination occur. But in that circumstance, it is egregious and obvious, and it is immediately before him. And in the vast majority of cases, including this one, it is not that clear cut. And as such, it would be improper in the vast majority of cases for a trial court to insert himself into the proceedings and to effectively, as Your Honors pointed out earlier, act as advocate. Certainly, again, there are scenarios like Your Honor has presented that would allow that to happen, but that is certainly not the scenario here. Here,
would it be more of under a circumstance like the one I've suggested, would we say merely that the trial judge had the ability to intervene, or would we say that the trial judge actually affirmatively had an obligation to intervene at a certain point?
I think the difficulties with making a Batson call at trial is difficult to impose an affirmative duty for that reason. And so I think it would be more of a permissive step in that instance. We wouldn't require him to turn a blind eye. And we would therefore vest him with the opportunity to do so. I think any judge facing those scenarios would do so. But again, it would need to essentially rise to the level of a per se Batson violation, which the hypothetical you've presented, Your Honor, does. It wouldn't be, as Your Honors pointed out earlier, merely engaging with step one of the Batson framework. There are many different.
So we're talking authority versus obligation.
We would be, Your Honor, although I don't think for the most part it would be permissible for a trial court to insert himself, as that would place him in the role of advocate within the Batson framework. The Supreme Court has made clear that those first two steps of Batson govern the burdens of production of evidence. And the third step is in fact the burden of persuasion. Those burdens lie with and never shift from the opponents of a strike. The language of Batson itself is adversarial. And to ask a trial judge to engage with that framework would ask him to step outside his role as neutral arbiter. As the Supreme Court recently held.
But, excuse me, but aren't there cases where the trial court will just skip over the step one and require the state to put on race neutral reasons?
There are cases where, for example, a defendant has raised an objection as to prima facie, and the judge will not necessarily rule, but then will ask the state for his race-neutral reasons. In those cases, the Supreme Court has made clear that on appeal, the question of whether prima facie was actually established does become moot. But we contrast that with, for example, the cases that he has cited in other jurisdictions, where the court has intervened sua sponte. Of the jurisdictions he has pointed us to, about half of them resulted in trial court error, and 1/3 resulted in brand new trials. And that is precisely because, as Your Honor has pointed out, it becomes difficult when he is inserting himself into this 3-step process.
But under Judge Yuri's hypothetical case, let's get back to that. Under his hypothetical case, are you saying that if the judge did not intervene, under those circumstances where it's that clear, when they say, yeah, we're doing it just because we want to exclude, this particular protected group, if the judge doesn't do anything under those circumstances, are you saying that that's not an abuse of discretion?
That would be correct, Your Honor. Without having a duty, we're not looking at that. However, it's also important to note that he doesn't only get one shot at raising a Batson allegation. In the scenario presented by Judge Yuri, he would be able to, especially where defense counsel is himself also engaging that would clearly be ineffective assistance of counsel, and that could properly be raised on collateral review. There are ways for this issue to get remedied, and they're established, and we present many opportunities to do that. But the best way is to raise the objection on your own. And that is why we put that burden on the defendant to raise that objection.
I'm a little bit confused though, because it sounds like from the example that your answer to Judge Yuri's question is, you're recognizing that there's some sort of an affirmative duty, but only in a really, really bad situation, only in an egregious situation. And so if we're going to say, so how do we fashion a rule that allows us to figure out what constitutes a truly egregious departure that requires the judge to step in? Or are you simply now saying, look, it's not actually duty, it's just authority, and their only remedy is to try and raise it on a writ?
I intended to suggest the latter, Your Honor. I don't believe that even in those circumstances, it would be a duty. He is just permitted to do so. And as such, I think the rule we would fashion is that in the vast majority of cases, it would be improper for a trial court to act as advocate and to insert himself into the proceedings. But certainly, to Your Honor's questions, if there was a particular scenario, again, we wouldn't ask him to look askance. We would permit that to happen, but again, we would not require it. There are multiple avenues for him to get relief on an issue or a circumstance like that.
Okay, well, another question then, though, is if it's going to be channeled into an ineffective assistance claim and the defendant is the one colluding with the prosecution to actually say, let's strike people for a race neutral or for an impermissible race-based reason, how would the defendant ever show he was prejudiced for ineffective assistance of counsel on the writ when he got what he wanted?
I think, Your Honor, that does certainly present some difficult circumstances as noted in Batiste, but counsel just cannot engage in behavior that he is prohibited from doing. So I'm not exactly sure what version of prejudice we would look at. I think maybe we would look a little bit more similar to what the Supreme Court found in Weaver, where it starts to get to the question of fundamental unfairness. That might be the way that we would analyze that, but certainly there is no strategic reason. Defense counsel should not be engaging in that kind of behavior ever. So it's not permitted, and it never would be permitted. And therefore, I do agree with my opposing counsel when she says that this is not a circumstance that we allow under Batson. And therefore, what we are concerned with when it comes to forfeiture rules is, does he have one shot? Does he have a clear shot to raising this? And Batson makes clear that there are many avenues for that. He should do it at trial when those circumstances are easiest to correct. You can either seat a jury who was improperly struck, or you can, as the statute requires, call a new array. That would be the best, most clearest policy reason to require it at trial. But had the circumstances been presented on direct appeal and he had properly objected, he may be able to get relief there. Similarly, there's still collateral review. There is also possibly federal habeas review. The question here is, do we believe that the best way to do this is at trial? And this court has made clear that we do.
Do you agree with opposing counsel that Mr. Falk, throughout the entire proceeding, the whole trial, just effectually sat on his hands?
I think that is a fair assessment of what appellant did in this case. During trial, he was very clear that he was going to hold the state to its burden. When asked repeatedly about, especially before he waived or before trial began, about whether he would be questioning jurors or witnesses, he said repeatedly, "It is the state's burden to prove their case, and I am not required to do so."
Did he confer with standby counsel throughout trial?
There's no evidence of that on the record. Prior to the start of the punishment proceeding, standby counsel did occasionally object, usually outside the presence of the jury. In fact, going to the Batson claim, the peremptory strikes were done in chambers with the judge. And at the conclusion of the strikes, standby counsel did raise an objection, but only as to an Eighth Amendment claim. He did not raise, and she did not raise, any objections as to Batson, even though that wasn't in front of the jury. And also he was not really supposed to be objecting on appellant's behalf, but they did.
Excuse me, but did Mr. Falk make any objections, any appreciable amount of objections throughout the trial?
He did not, Your Honor.
Okay, thank you.
The only thing that he did was during voir dire, where he would occasionally agree with the state to excuse jurors. He did ask, I think, a total of 5 different jurors questions, including the 4 I was referencing earlier. But at the merits part of the trial, he did not ask any questions or raise any objections, except for to one inmate.
So you would agree that he just effectually sat on his hands throughout the majority of the trial?
I think that's fair to say, but that's also his choice. It's also what he was allowed to do constitutionally, and when he exercised his right to proceed pro se. And to now go back and, in hindsight, ask more of the other actors in the trial simply because he's second guessing the decision that he made is not sufficient to create new rules.
Okay, thank you.
If Your Honors have any questions about the factual basis claim in point of error 11, just very briefly, I would like to point out that Article 1.15 requires and allows many forms of evidence, including the punishment proceedings. And here, to Your Honor's questions earlier about the stipulation, it was clear that he stipulated and confessed to both the indictment and to the stipulation, which had additional language with regard to whether he was acting alone or as a party. Appellant is merely using the fact that we have, that this case is unique, that we have evidence here of precisely how the state was going to proceed in this case because appellant sat through that previously. But that's not required. And in the vast majority of cases, defendants don't necessarily know the state's strategy before pleading guilty. Here it was, the indictment alone was enough. And if that wasn't, the reference to either principal or party in the stipulation was sufficient. And even if that wasn't, then the evidence of punishment is still yet more sufficient. This court found on the mandamus proceedings that the evidence presented by the state at trial in the original trial were some evidence sufficient to raise the issue in a jury charge, and that some evidence would be equally applicable here under the factual basis claim. If Your Honors have no further questions, I'm out of time. So in sum, for all foregoing reasons, this court should overrule his points of error and affirm the conviction. Thank you.
Thank you, counsel.
Thank you, Your Honors. The state has effectively conceded that in a case of an egregious, obvious Batson violation immediately before the trial judge, that judge has the authority to intervene. And with the authority to enforce constitutional protections becomes an obligation. Equal protection is not optional. And unlike a public trial, the harms that flow from a Batson violation are not just those of the defendant, but also the excluded jurors who have been openly discriminated against in open court. And the harms also undermine confidence in the proceedings, because at the outset of a criminal trial where the trial judge allows open discrimination to occur, what confidence can citizens and the jurors themselves have in the process following that?
But counsel, the facts of this case are not exactly the same as the hypothetical that I posed. Might not the facts of this case justify some lesser way of looking at it, if you see what I'm saying? Maybe the judge didn't need to intervene, and so he didn't abuse his discretion? And that's what I'd like for you to address.
Well, I think the difference in the hypothetical, the way I perceive it, is the explicit statement by both parties that race or gender was the reason. But the collusion is clearly here. And without having to justify the strikes in any manner, we don't know what the statement from the state would say and if they would be credible reasons. So if this court is inclined more to find the authority of the trial court to intervene in this circumstance, then the prosecution would have an opportunity to provide permissible reasons for the strikes. And
Wait, you're saying that the collusion is clear here, and by whose standard? The state's not conceding.
The trial court made several statements on the record acknowledging that this was not a contested proceeding. He acknowledged that Mr. Falk was, well, standby counsel said there was a conspiracy, and the state reacted poorly to that, which I understand. And the trial court said, maybe not a conspiracy, but clearly Mr. Falk is agreeing with everything the state does. My opponent pointed to several instances of the record
which
where
is
Mr.
his
Falk,
right.
well, true, Your Honor, but then the question remains, what minimal constitutional protections does the trial judge have to enforce? Mr. Falk was aware that—
Excuse me, I have a little difficulty when you say that because he has the permission or the ability, legal ability to intervene, that he somehow has to. Because that's what you seem to be saying.
I think where he has the authority to enforce a constitutional protection, a trial judge must. I see my time is up, but if I may briefly conclude. I think in this, thank you, Your Honor. In this case, Mr. Falk took no action and the adversarial process was simply not functioning in the way that we require it to do. So there are certain minimal protections that the trial judge must enforce. With that in mind—
That's his choice. I mean, that's his choice, isn't it? To represent himself. It's a bad idea, pretty consistently a bad idea, but he's chosen to do that. And what you say, yeah, he's chosen to do that, and we're going to remove from him all the obligations or all the liabilities that go with that, because we're going to insist that the judge act, at least to some extent, as an advocate.
I think the judge's duty at bottom is to ensure that constitutional protections are observed in a criminal trial. And that's what we're asking for here. Respectfully, we request that this court reverse the conviction of Mr. Falk's case. Thank you.
Thank you, counsel. The case is submitted and the court stands in recess.